So let me start by thanking Vince for inviting me to participate in this. I feel a little bit outmatched because Mary Ellen's a distinguished international law scholar, and I'm actually a journalist. I sort of dabble in these areas, and I'm a little bit, I like to think I have something to say on them, but I don't hold myself out as an expert on international law. One of the things about being a journalist is that you do hopefully develop some expertise in common sense. And I want to approach this question from the point of view, start from the point of view of common sense and then go to doctrine. Because I think one flows much more easily from the other than the latter flows from the first. If you take what Mary Ellen just said at face value, that is, to deny that the use of force is ever appropriate, targeted killing is ever appropriate outside of an immediate zone of armed conflict, and you define armed conflict very narrowly, as she does. And you further deny, as she also does, that it is ever appropriate for CIA personnel to engage in lethal force and to participate in these sort of activities. There is a conclusion that follows from that, I think ineluctably. And that conclusion is that the President of the United States is a serial killer. And I don't know that that's an avoidable conclusion. I think the conclusion would have to be that this is not an authorized use of force. It's not an appropriate, it's not confined to the territorial boundaries of an armed conflict. And it's being done by personnel who aren't necessarily authorized ever to use force, even in an armed conflict, all under the specific orders of the President of the United States, who, let's go a step further, campaigned on a promise to escalate the sort of meager serial killing that his predecessor was engaged in, who, furthermore, criticized his opponent in the campaign for being insufficiently committed to serial killing, and proceeds to get into office and do precisely what he promised, which is to escalate the existing sort of low-grade serial killing that's going on around the world. I think under Mary Ellen's theory of the law, the president is really no different from Ted Bundy, or to put it in fictional terms, Hannibal Lecter. And Harold Coe, whom Vince described as revered by many in the room, would clearly be guilty of conspiracy to aid and abet serial killing, to conspiracy to serial kill. I'm not sure what the term of art for that would be. And so my question, which I mean only sort of rhetorically, and partly I would love to hear Mary Ellen address, is what is the difference between the president and a serial killer, or just garden variety serial killer? And number two, if in fact I'm not misunderstanding her legal argument, why are we having this sort of very staid discussion about whether the president, whether this is, these sort of constituent components of this gestalt awful fact, and why are we not talking about impeaching and removing the president and putting him on trial for myriad, hundreds and hundreds of killings around the world that are unlawful? Now, I would love to hear Mary Ellen address that, but let me step back before I yield this and say, I think the president is not a serial killer, and I think Harold Coe is not guilty of conspiracy to aid and abet serial killing by the president. And if you believe that, then there simply has to be something, at least something, and I would submit several things, defective about the underlying legal theory. One of them is the question of who can be targeted. And the answer to that question is not nobody outside of a very narrow territorial zone of armed conflict.
First, let me say that I take these matters incredibly seriously. I do not dabble in them. We are talking about questions of life and death. We are talking about questions of the good name and honor of our country and of persons who are asked to serve this country. I am married to a highly decorated combat veteran. When he went to war in the Gulf, to liberate Kuwait, he did so under clear knowledge that he was honoring the United Nations Charter, honoring the United States Constitution, honoring the Geneva Conventions. He was the Geneva Conventions trainer for his entire battalion. He came home from that war with a clear conscience. He does not suffer from post-traumatic stress disorder. And he understands how important it is that everything we ask our serving men and women to do should be strictly in compliance with the rule of law. And that those who do not know this law, who simply dabble in it, who like to have websites that talk about lawfare as if using the law and supporting the law was the same thing as using lethal force in warfare, should not be engaged in that. We need to have clear rules when we send our people into harm's way. And one of the things that is the legacy of the Bush administration that I think many of us are so very disappointed to see has continued in the Obama administration is a failure to renew our commitment to the law as written, to what we all in the international community accept to be clear rules of law. They must be clear if we're talking about life and death. We should never talk about taking human lives lightly or without a clear justification within the law. Ben's argument relies almost entirely on the logical fallacy of the ad hominem argument. He thinks that we should stop and think, who are these people who are involved? Is this President Obama? Is this Harold Koh? Therefore, we should stop there and not think about what the rules are, the justification, the citations to authority that we should, as lawyers, be looking to before we decide whether or not our president is acting in conformity to international law or not. And I'm sorry to say, very sorry, because I do have great respect for Harold Koh, but in Harold's speech in March at the American Society of International Law, he did not cite any authority except the UN Charter, Article 51, and on that basis, we cannot find, looking at the authority for the interpretation of Article 51, as well as its plain text, justification for the use of killing outside armed conflict territory. The other logical fallacy that Ben makes, in addition to relying on the ad hominem argument instead of actual clear legal justification, is that he has failed to understand, he's tried to make this zero-sum argument, as if you can't find a way to kill individuals under the law of armed conflict, you can do nothing. Maybe we should call this the Chicken Little logical fallacy. It is certainly not true that the only thing we can do is kill people with drones or with secret commando. We're supposed to be talking about drones today, but it's understood very likely that many of the people on the president's kill list who are outside of Afghanistan will be killed through special operations and covert operations by the CIA or others. Well, we know that there are other means. We know that there are other means, and in fact, other means have shown through studies to be the effective means. So even under the law of armed conflict, even if we were going to say that we had an initial right to kill outside the hostilities of Afghanistan, we would have to justify any of these actions also under the principles of necessity and proportionality. Necessity says that you must be able to accomplish more good than harm. You must be able to accomplish the military objective through use of lethal force and other military measures. But in fact, we've been told by counterterrorism expert after counterterrorism expert that military force, the blunt killing of individuals outside of armed conflict hostilities, is not how you succeed against terrorism. The 2008 RAND Corporation study says that the way in 93% of the cases you have succeeded against terrorist groups, repressing and ending them through incorporating them into the political process, number one, and number two, through law enforcement measures. And that is what the United States had done consistently until 2001, law enforcement. That is what has worked for the British, that is what has worked for others. So it is so put away these two fallacies that just because it's Harold Koh or Barack Obama, we lawyers put down our law books at the door. And number two, don't think in these narrow terms that have been built up over this amount of time that all we can do is kill people. It's unsophisticated, it is uncreative, and it is unlawful.
So just to clarify a couple of points. Just to clarify a couple of points. I don't believe that I ever said that all we can do is kill people. What I said was that there are a certain number of cases, and there are a number in the hundreds, in which that is in fact what we've done. And what I've observed is that, understanding Mary Ellen's argument, those would have to be understood as murders. And that if you understand them as murders, and in fact in her papers she describes them as CIA crimes, and specifically describes them as prosecutable, with reference to the CIA officers in question. My point is that these are not simply acts by CIA officers. They're acts by CIA officers at the direct orders of the President of the United States, both in this administration and in the last. And that if you understand them in the way that she does, you are therefore understanding both of the last two administrations as composed of serial murderers. And so I believe that there's something defective about that, that it just doesn't comport with my sense of reality. And so let me propose an alternative way of understanding the question of who may be targeted. A state of armed conflict came into existence in the fall of 2001 at the latest in Afghanistan. Under international law, we think of that as a non-international armed conflict, and you can target people who are directly participating in hostilities on the other side. Under domestic law, we have the AUMF, the authorization to use military force, which the courts have interpreted actually in a somewhat different context. But in the context of habeas litigation in Guantanamo, the administration has asserted, and the courts have by and large accepted, that you can detain people who are part of or substantially supporting enemy forces. Now, I think these two broad propositions, and understanding that the administration takes a rather broader view of direct participation in hostilities than, say, the ICRC does, I think broadly understood, these two instruments give you a pretty good sense of who can be targeted. And you know, you can say, as a blanket matter, that the state of armed conflict is limited to Afghanistan. But I'm really unaware of any history of state practice of being in conflict with an organization A that straddles the border between countries X and Y and asserting no authority to cross that border and target members of that force, members of that group with lethal force. And so I think the answer to the questions of who can be targeted and geographically where are intertwined. But the broad answer to the first question is you can target members of the enemy under both international law and under domestic law. And I think that's a way to understand what this administration has done and the last administration has done that does not require you to believe that they are composed of Hannibal Lecters and Ted Bundys.